Can you hear me out there? Oh, shit. Does it look like we're a bunch of talking heads up here? We're saying that this is a beautiful chamber, but because the seats are so low and this is so high, when you walk in, all you can see are these little heads looking over. Ready? Thank you.
Thank you very much for your patience. I apologize for the delay in starting the afternoon session. We did have commission business that required a vote by the commissioners and a discussion with respect to two reports that we're going to be completing. So I appreciate your patience. So if the Executive Director could call our next panel, please.
Our next witness is Jose Ramon Fernandez Peña. He's the Policy Chair at Imprint, an organization focused on integrating immigrant professionals into the United States workforce. He is also the founder and a director of the Welcome Back Initiative, a program which since 2001 has helped internationally trained health professionals enter the United States workforce. Welcome.
Welcome and thank you.
Thank you. Good afternoon. My name is very long, Jose Ramon Fernandez Peña. I'm the Associate Chair of the Department of Health Education at San Francisco State, where I'm also an Associate Professor. As was stated, I am the founder and director of the Welcome Back Initiative, a program that was started to work with immigrants who were health professionals in their countries of origin and are already living in the United States to assist them in the process of re-entering the health workforce in this country. I thank you for the opportunity to speak with you today. You have received my written testimony, so I just want to highlight a few points in it. California is facing critical shortages in the health sector, and we do not have the physical capacity to train all the new health workers we will need in the next 15 to 20 years. Against that background, there are over 1.7 million high-skilled immigrants in California alone, and many of them are either on or underemployed. It is also presumed that many of them were in fact health professionals in the countries of origin. These foreign trained health professionals are an untapped resource that could help us fill some of the vacancies in the health sector, and at the same time, they represent an opportunity to improve the cultural and linguistic diversity of our health workforce. And I want to refer just for a second to the comments of Ms. Schroeder earlier today, in the sense that licensure is indeed a critical component of ensuring patient safety, but amendments to the licensing standards alone will neither resolve, might provide a minimal improvement in the diversity of the health profession. That said, some of the language included in the Health Professions Code seems to be there more for turf protection than for patient protection purposes. A professional integration of these 1.7 million high-skilled immigrants in California means economic development for themselves and therefore for the state, less dependence on federal, state, and local assistance, and this economic integration will inevitably lead to social and ultimately civic integration, fulfilling the goal of achieving a rich and diverse society. With this, I'm ready for your questions.
So, of the 1.7 million, many of them are foreign trained or simply foreign born?
The defining characteristic here is foreign trained.
Okay, got it.
Because you can be born in the U.S. and trained abroad.
Got it, okay.
So here, I'm sorry, here we're talking about immigrants
okay.
that are high skilled.
Right, so, and they have, the 1.7 you're referring to are foreign trained as well as immigrant?
Correct.
Okay, got it. You said that the changes to the code were not enough. What more can be done? Is it reciprocity? In a previous iteration, maybe, and you may have worked closely on this, I think there was something with the medical board and reciprocity with foreign medical schools for primary care. We have a shortage of primary care physicians, for example. I think that was a regulatory decision that several legislators were trying to push the medical board to embrace, if my memory is correct. It may have been 2011 or 12. Are you familiar with that effort or the work around that?
I'm familiar with an earlier effort
Okay.
in the early 2000s that Senator Marco Fireball introduced
Yeah,
the
yeah.
Fireball bill that was introduced, passed, and then failed to be enacted because one of the key players, the University of California, was not interested in participating in what they were proposing.
Oh, okay.
But to your other point, there are already a concrete situation with Canada where a physician trained in Canada can come and take the licensure exam in the United States and be given a license and practice. It's the only country with which the U.S. has reciprocity agreement for licensing physicians.
Oh, and so is that a federal process rather than the state?
It's neither. It's actually a national process. It's not dependent on any particular branch of the federal government.
Okay. And of the 1.7, you did mention that healthcare was pretty significant. Is that where most of them are, of the 1.7?
It varies. It varies by area, by state, by region, so not necessarily. Not necessarily. Many of the individuals that are high-skilled immigrants in California may be in other fields of engineer or STEM or other accounting, banking, other multiple areas.
And generally speaking, do you see yourself as advocating for either reductions in requirements of scope or practice? Okay.
No, not at all. It's very important, and I've had long conversations with Department of Consumer Affairs, working with foreign trained professionals. I'm speaking only about the health sector.
Okay.
To enable them or to license them to work in the United States, I think they should be held to the same standards as everybody else.
Okay.
Our work has been to ensure that that happens. Okay. That said, I think there's some aspects of the Health Professions Code that beg the question, why is this language here?
Okay.
Why can't a foreign-trained dentist who may have 12 years of practice experience sit for a licensure exam like any other trained dentist in California and instead is asked to take 2 additional years of training when that did not exist in the books until 2003?
Got it.
Why can't a foreign-trained dentist with the same 12 years of experience not sit for the licensure as a dental hygienist? Or why don't we even think about creating an advanced standing training to not require that foreign-trained dentist to acquire an associate degree, 2 years, plus all the prereqs that go into that 4 years, so they can come out as a dental hygienist?
Got it.
So there's an inherent, if I may say so, arrogance on the quality of the training that may happen in the United States that negates that any other place in the world is capable of training individuals on basic sciences, anatomy, physiology, pharmacology. I understand the need to train individuals in the particular aspects of the profession that may be unique to the United States. That's not a 4-year curriculum.
Got it. Is language at all a barrier? Last question. Is language at all a barrier for some of these highly skilled, previously practicing in some instances, I'm sure of the 1.7. I didn't think about that initially, but your comment begged that. Professionals, particularly if you're not interfacing with the public, are there ways that we can improve language access in order that these professionals more easily access the marketplace, the workplace, the training, or certification regime?
Absolutely. One of the first things we encountered was that among the non-structural barriers, the individual level barriers that our participants encountered was the lack of command of the English language.
Okay.
And the existing offering of ESL curricula across the state and across the country really did not meet that need. So we developed an accelerated health-focused English as a second language curriculum, which is offered at a number of 56 institutions in the United States right now and 3 places in Canada. It's offered at City College of San Francisco, among other places. And it's 320 hours of instruction plus 40 hours of listening exercises that can be done in 1 year and takes a person from, I don't speak English, to, I'm going to take your blood pressure now.
Got it. And that's a pretty advanced course of language, is it not? I mean,
It takes individuals at an intermediate, low level of English and takes them to being able to communicate effectively with patients, coworkers, families, and supervisors.
And just one last, I'm sorry to dominate the question, but the demographics of the 1.7, gender and ethnic, do you have a snapshot for us?
I don't have the demographics of that particular 1.7. I can tell you of the almost 15,000 people that the Welcome Back Initiative has worked with, about three-quarters of them are women. And what can I say? Off the top of my head, I have some. Three-quarter are women. About 66% of them are not working in the health sector when we meet them the first time. Over half of them have an intermediate high level of English when we meet them the first time. About half of them have been in the U.S. fewer than 3 years. And what we see are primarily nurses, doctors, and dentists. They come primarily in California. About 76% of them come from Latin America.
Okay.
We have seen these 15,000 people from 167 countries. On average, they have at least one dependent in the U.S. and maybe more in their countries of origin.
Thank you.
Thank you for what you do. A couple different kinds of questions. You referenced the agreement with Canada on physicians. Would it be a good idea to develop a similar program so that the state licensing apparatus and the affected profession could be deeply involved? So I noticed, for example, in looking at the statistics about California nurses, that a very substantial percentage are Filipino. So would it be feasible to develop a program where there was an opportunity for examining the quality of the education in a country to facilitate the entrance of people from that country on the basis of, I'll call it quasi reciprocity or endorsement? There may be some things that are going to be different one country to another, but a streamlined process.
That sounds good on the surface. I'm sure it's much more complicated than that. In the concrete case of Filipino nurses, for example, most schools in the Philippines use a U.S. curriculum in their classes. So they are trained to the U.S. standards with a U.S. perspective in mind, and they are more often than not ready to take the NCLEX exam to be licensed in the U.S. They may be found deficient in a couple of areas. Psych, Peds, and OB are the typical ones, and then they may need to take those courses to make up the deficiencies. But it's almost an industry in the Philippines for a number of reasons. They produce more nurses than they could possibly need. They export these nurses, and these in turn bring back remittances to the country. So it's a complex process. I'm not old enough to know when the agreement with Canada was made, but there may have been some kind of similar situation. When the California Dental Association successfully advocated for the elimination of the bench test in California for foreign-trained dentists, the window they opened was to allow foreign dental schools to apply for licensure or accreditation from California. Applying for accreditation, among many other things, would mean that the school meets OSHA regulations. And a school in, I don't know, Panama may not be interested in that, or may not have the funds, or say, why would I want to do this? Only one school has followed that U.S. accreditation, and it's actually in Mexico.
So how would you respond to the legitimate critique of the people who advocate for empowering a specific state to have requirements that good moral character or things that are not test-driven? Is there particularly in the healing arts that you're talking about, is there a template that you think is appropriate for when graduates of, I'll call it accredited foreign training programs, education programs, come to the United States? Are there things that should be looked at beyond the testing regime good moral character, previous convictions, hard to do? I mean, what are the barriers that you believe would be legitimate? In other words, you're in charge of making sure that no immigrant coming with a graduate certificate from a foreign country does anybody any harm. So if you were in charge of that, what would you put in place to make sure there are criteria beyond a test?
Well, I don't know. Certainly, I would look to see that the school where this person obtained their degree is a legitimate school, and the licensing entities and the credential evaluation entities, which are separate, have means of looking into that. How can I know that a person has good moral character? It's such a culturally driven opinion measure standard that I don't know that there would be an objective way of assessing that. And moreover, I don't think that any of those, what do I call them, moral or social standards are in fact barriers for licensure of individuals. The real barriers start when we are unable to give credit for any education obtained abroad, or we are unwilling to give any credit to that education.
The accreditation issue is interesting to me, because you could find the, Harvard of France, or the Sorbonne of America, if you want to play it on both sides. The point being that either country could accredit the other school's curriculum. Why hasn't that happened?
Well,
How much time do you have, right?
How much time do you have? Right. But, I mean, I don't know why it's not happened. I know that it's, Canada, for example, has established a series of agreements with other English-speaking countries, New Zealand, Ireland, the UK, and Australia, where they have created a program for physicians from those countries to come and work for a period of time under the license of a Canadian doctor for a year, and then they are considered good to go and they're given their own license, provided that they don't screw up during the process. In the late 90s or early 2000s, the European Union got together in the Bologna agreements in order to recognize the training of individuals across their countries, right, to facilitate the free traffic of people and goods in the European Union. In fact, one of the promises of NAFTA was to do something similar along the three countries, and parts of it have been enacted with Canada, none of it has been enacted with Mexico. So why has it not happened? I frankly think there has not been the will to make it happen.
This is a basic question that comes from a place of total ignorance, which is, what is the accrediting body for, say, a medical school? Is it a state body? Is it a national body? Is it a quasi-public entity like AMA?
It's, I believe it's actually a component of the AMA, which is the ACGME, Accreditation Commission on Graduate Medical Education. ACGME, Accreditation Commission on Graduate Medical Education. And in addition to that, there is the states have to make sure that the schools are accredited to whatever their standards are.
Right. It's interesting. We just finished a report on Denti-Cal, and there's a real need here for qualified dental hygienists and obviously dentists. The idea that a trained dentist can't practice as a dental hygienist is strange to me. But to the extent that you could go to, at least to the extent the state has the ability to be a magnet for talent and has the means to push the accreditation process forward to the extent it can without having to get the permission from the AMA type, you could easily imagine a situation where you have a kind of deal where you say, those students who, say, come from an Indian school that is accredited by the state's dental board, or whoever would accredit, with whatever blessing is needed from the dental associations that does nationwide crediting, you come to America, and you take whatever the requisite licensing exam are, and then you spend a period of time before you can move on to the full dentistry practice, doing something in public service. It just strikes me that to the extent the state isn't dependent on federal accreditation or on some other entity accreditation, it might be worth exploring that route. Because to me, it's an opportunity for the state to attract talent, but also to fill a desperate need.
I think you're right, and I think that for me the question remains, is some of the language in the health professions code more protectionism and not necessarily of the patient? Why did we have a perfectly valid and legitimate process to relicense foreign trained dentists, and suddenly we eliminated the one test that made that happen? I think it begs a question. I'm not saying, again, I'm not trying to lower standards for accreditation or licensure. I don't think that would be a good idea. I think we need to look at these things critically and ask the question, could it be done differently?
Yeah, let me play devil's advocate here for a second. So if you go to law school, you either go to an accredited law school or non-accredited law school. And if you go to an accredited law school, you can take the bar. If you go to non-accredited, you have to take what they call the baby bar. But when you finish and you take the bar and you pass it, it doesn't matter if you get the score, 70 or above, it doesn't matter what law school you went to, because it shows that you have competence and understanding the legal principles. Why don't we apply that same standard to like doctors? If you're a doctor who's been practicing for 25 years, even though you didn't go to an accredited school in America, if you can go in and pass whatever the qualification test is, and if English is a requirement, Spanish, whatever the requirement is, if you can do those two things, what do we care about where you went to school?
We exactly do that with doctors. We do that with doctors. We don't do it with dentists.
Oh, it's only the dentist, okay.
Correct.
All right.
So a foreign trained doctor comes to the U.S., demonstrates that their education is equivalent to the education of a U.S. trained doctor, and then they jump into the pool with everybody else that just finished medical school and enter residency.
Same thing as law school, okay.
Sort of.
Almost, yeah.
The difference is that a foreign trained doctor may have 20 years of practice in your France or my Mexico or your, wherever, and they enter the pool of applicants to residency training.
So just one last question. You mentioned a number of American citizens go and get training outside the country, then come back in.
So, for example, I believe somebody's going to talk about military issues. Military brats whose parents are posted to Germany, and they decide to go to social work school in Germany. When they come back, they're foreign trained. They're on the same boat as any other immigrant.
And they're brats.
They're brats.
I said that lovingly, no offense to anybody. But the point is, the children of diplomats maybe, who are posted to Ghana, and they go to nursing school in Ghana. When they come back, they are foreign trained.
Commissioner Beyer just pointed out that you actually don't have to go to law school. If you just take the bar and pass it, you're okay. In California, yeah.
5 states.
5 states.
Any other questions
Thank you.
from commissioners? I think it's ironic that when you take a look at a state like California with a significant population of Latinos and a large number of Spanish-speaking patients, their interests are better served by physicians who speak Spanish. And we're constantly looking for physicians to practice medicine in areas of communities that have non-English speaking, whether it be Spanish or some other language. And so that ought to be, quite frankly, that ought to be considered a plus in terms of their suitability.
There's a number of important studies that talk about what the lack of parity between the health workforce and the population seeking health services does in terms of health outcomes. Mm-hmm. And when you improve that parity, the outcomes tend to be better across cultures, across languages, and this may be true across genders, sexual orientations, a number of demographic variables. Mm-hmm. What it's also is, it's a missed opportunity. This is not about going to another country and bringing a busload of nurses or doctors from anywhere else. This is not about poaching and engaging in brain drain practices. This is individuals who are already living in California or who are going to come to California for one reason or another. We see a number of individuals in the Bay Area that one of the spouses works in Silicon Valley in Google or somewhere, and the spouse is the psychiatrist or the dietitian or the someone, and they have to stay home or do something else because they cannot use their skills or talents here. So it's a waste. It's what we refer to as a brain waste.
Right. Very good. Thank you very much for your testimony.
Thank you.
Our next witness is Lori Crehan. She is the Southwest Regional State Liaison for the Office of the Deputy Assistant Secretary of Defense, Military Community and Family Policy within the U.S. Department of Defense. Welcome.
So, on behalf of the Deputy Assistant Secretary of Defense, I want to thank you for this opportunity to come and talk to you about concerns that we have regarding licensure and two groups. One are separating service members who come back and need to get an occupational license to be employed, and the second group are military spouses of active duty service members. I am an employee of the Department of Defense State Liaison Office. We created our office to work with state legislators and policymakers to address those military family issues that are within the purview of the states, and certainly licensure is one of those. We have been working for the last 11 years, and for almost that entire time, licensure has been on our list of top key issues. It's becoming even more important now as we draw down out of the Middle East, and also as many of our services are declining in numbers. We have a lot of our military members joining the workforce. A few years ago, the numbers of post 9/11 military members unemployment rates were much higher than the national average. I'm happy to report that that's no longer true, and in fact, overall, their numbers are actually lower than the national average. However, we do know, and I don't have the specific number, but that our separating service members in the 18 to 24-year-old age level still continue to have high unemployment. You have my testimony that goes into the details. As with the previous speaker, we also are not seeking to lower standards or requirements of the state, of the licensing boards, but we do want to look at how we can, for separating service members, have those licensing boards accept their training, their education, their experience towards requirements. And we know that a lot of our service members go straight from high school or even college into the service. Their peers enter the workforce and start their careers. They go and serve their country, and then they come out and often have to start all over, even though they may have been working as an electrician or as an MP or as an EMT for 4, 9 years, 20 years. So we are encouraging those licensing boards to take a look at how they can accept that. The active duty spouses is another issue. Our spouses move usually every 2 to 3 years. They get to a state. We are saying if they come to a state and they already have a license in good standing from another state, we would like states to either endorse that license, provide them with a temporary license while they meet unique requirements of a state, or and also to expedite that process. And the reason that's all important is that spouses come, they spend 6 months, is what they say on average, sometimes longer, to meet the state requirements. Then they enter the workforce looking for a job, and often employers don't want to hire someone because they know they'll only be here for another year or two. It's not fair to our military spouses that their careers are put on hold or not even able to develop, but it also, we know that spouses play a big role in whether or not the service member decides to stay in the service. And so it becomes a retention and a readiness issue. And thus, while the Department of Defense cares very deeply about our families, we also really care deeply about national security. And we think that it plays a role in that because we have people leaving the service that should stay in.
Could I interrupt just for a second? Well, what percentage of spouses are we talking, 5,000, 10,000?
Percentage,
Well, I mean, just what's an idea of how many spouses are moving around and have certification where they can't get certified? And that, big problem, huge problem, little problem?
68% of service members report that their spouse is or no, that's not the one. I don't have the exact numbers, how many have licenses, but 70% of our spouses say they need to work or want to work.
Okay, but that's a little bit different issue than the licensure issue.
Than getting their license,
Yeah.
yes. I don't have that exact number,
That's okay.
no.
And thank you to our witness for your work. It's extremely important. So in the information that we have here, it lists some of the states that under discussion points that have some kind of endorsement policy or license amendment. 43 states with temporary licenses, 34 states with expedited reviews. California in any of those categories?
Yes.
Okay.
California provides temporary licenses, primarily in the health professions.
Okay.
And they also, a bill was passed to provide expedited licenses for all areas, although expedited is not defined.
Oh, expedited is not defined, okay. Was that recent legislation?
The temporary license bill passed last year.
Okay.
The expedited, I believe, was 2 or 3 years ago.
Okay, so they're both relatively
new.
new, so it'll take a while. For example, if something was passed last year, depending on how it was written, it would not have become effective until January.
Correct.
So these are brand new then.
And I have to say that almost immediately after the bill was passed, there was a notice on the Department of Consumer Affairs website saying, if you're a military spouse, please identify yourself and we will work to expedite. So we were very pleased to see that.
2 additional questions. What kind of numbers are we talking about in terms of the individuals that would be affected by such policies in the state of California? Military spouses or returning servicemen and women?
I don't have that number.
Okay.
California has the largest military population in the country. There are over, I think, 150,000 military members, so I don't know, 70% are married.
Okay, good to know. And then the second question, what distribution of licenses do we see with the spouses or the returning? Returning might not be as easy for you to quantify, but are they in the construction trades? Are they in healthcare? Are they in other regulated professions in California?
Well, 3 areas that the Department of Defense has really focused on are EMTs, licensed professional nursing, and commercial driver's license.
Okay.
But we also know we have many people in the construction industry also. California has, in many of their trades, a really strong apprenticeship program for military. And so that has really helped facilitate getting them into jobs immediately.
And additional information on this topic would likely be in the analysis of those bills. I don't know, do you work on those 2 pieces of legislation?
Yes.
So there would be additional background information. We don't already have it in our report, so thank you.
I would like to also say on the spouse side, nursing and teaching are the two main. We've made progress in nursing. We've made very little progress across the country in teaching, partly because they get licensed outside of consumer affairs or whatever that licensing agency is. So it's a whole nother tact.
Thank you for what you do, and thank you for your testimony. A couple different questions. If I remember your testimony or some reading on this topic, it seems to be the case that spouses and returning veterans are somehow seen as the Trojan horse for dismantling licensing schemes. That is, if you permit an exception for spouses, then pretty soon the exception begins to cause corrosion on the licensing side. So with that in mind, can you just dimensionalize the size of the U.S. military that is active duty? 1.3 million, is that about right? And of the,
I can make it.
and then.
I'm not sure.
Okay,
I'm not sure.
I think that's right. So
Sorry.
relatively speaking, the percentage of African Americans, Asians, Latinos is higher than the general population. Is that a fair statement?
In the military?
Yes.
Actually, the racial breakdown reflects the same
Society in
the
general.
U.S.
Okay.
population.
And correct me if I'm wrong, that I thought you referenced teachers as a spousal occupation that was the trailing spouse issue. Somebody's got a teaching job in New York and their spouse is transferred to California to a military facility, that the teachers are the most common sort of employment challenge. Am I remembering that correctly?
Well, certainly, very few states have taken a look at how they can facilitate for teachers, spouses, a way of getting them into the workforce quickly. There are a lot of other peripheral issues too, like they never get tenure, they're always temporary employees because they leave, so they don't get vested in a retirement program, so there are other issues there too. But yes, teaching is certainly a career that many of our spouses went into because, of course, we know it's portable, but it really isn't.
So is there a step that California should take with respect to trailing spouses on the teaching front, legislative or administrative step?
We would like them to take a look at how they can make it easier, whether it's providing temporary licenses, which they will do, many states, including California, if it's a need, like science, math, special education. So there's already a precedent for that. But we would like them to look at how can they get teachers into a school working. Maybe they're closely supervised as a new teacher would be through a BITSA program, but yeah.
Recognizing how difficult it is for a kid who's been in the Army for 2 or 3 years to come out at 22, 20 to just get a job, there must be some programs someplace in the country that are really having a good impact on that. Is there something you could recommend to us to say, boy, New Jersey, they're doing this and it really works?
Well, as I mentioned, these apprentice programs, the boots to helmets, or there's
With boots on the ground? That's in Iraq?
No, it's the construction industry that I think it's.
Oh, so in other words, while they're in the military, they're developing their credentials, actually give them a certificate to use to get out? Is that what they use?
Yeah, along those lines, the Department of Defense has really stepped up to say, okay, a lot of states require that they had to have been in an accredited program. Much of their training is not accredited in the military. So now they're taking steps to get their training programs accredited.
That'd be an example of a really good.
Another action they're taking is they're taking their programs of instruction and they're doing a crosswalk with what are the requirements for state licensure, so that military's language is made more accessible to licensing boards, so that can.
It's almost like your military experience becomes an educational program, that when you get out at the other end, you actually have something other than just a service.
We would hope.
Cool, thank you.
Thank you. And seeing no further questions from the commissioners, thank you very much for your
Thank you very
testimony and the
much.
information.
Our last witness today is Tracy Ryan. She's the Chief Deputy Director at the Department of Consumer Affairs, where she oversees the department's internal operations, including interaction with the state licensing boards and bureaus. The department issues licenses in more than 250 business and professional categories.
Thank you.
Good afternoon. I will try to be brief because I assume you have many questions for me. So again, thank you for allowing me to speak today on behalf of the department. My name is Tracy Ryan. I'm the Chief Deputy Director for the Department of Consumer Affairs. In this testimony, the department was asked to give a brief overview of the structure of the department and the differences between the entities within the department. We are comprised of 40 total programs, 26 boards, 10 bureaus, two committees, 1 program, and 1 commission. These entities regulate and issue licenses to more than 250 businesses and professional categories. From the department's perspective, licensing plays a critical role in ensuring consumer protection. First, if a licensee violates any part of the Practice Act, the board can work to educate the licensee and help prevent future violations. If issues persist or violations are severe enough, disciplinary action can be taken against the license, including fines, citations, and revocation. Taking disciplinary action is the ultimate authority a board has to restrict or remove bad actors and protect consumers. Next, I want to talk about the differences between, I'll call them generally boards, which include commissions and committees, and bureaus within the department. There's a different governance structure between the boards and bureaus. Boards are semi-autonomous entities with appointed board members that set their own priorities. If a board has a policy issue that it wants to pursue, it can vote to seek a regulatory or statutory change during one of their public meetings. Boards can take positions on legislation, make changes to state law, and take disciplinary action on their license. Bureaus are a direct extension of the department and cannot act on policy matters without first consulting with the department. Policy decisions start at a bureau level and must be vetted up through the department, agency, and ultimately the governor's office. Administratively, the director of the department can delegate authority to the bureau chief to carry out licensing and enforcement duties. Next, I was asked to touch on the role of the department in our rulemaking process. In regard to the rulemaking process, when a proposed regulation is approved by a board, the staff prepare a regulation package for public notice and initial publication with the Office of Administrative Law. After publication of the regulation, the official public comment period begins and board staff submits the regulation package to the department for official review. The department conducts a rigorous review of every regulation for its legal, economic, and policy impacts. In 2015, the department reviewed 93 regulatory packages. Based on the review of the department's executive staff, a position is recommended to the director for approval. If there are concerns with a regulation, the department's executive staff work with the board and the stakeholders to resolve the issues, or the department director can deny a regulation altogether if it is determined to be detrimental to the public health, safety, or welfare. The process is slightly different for bureaus as they are directly under the department. We will officially review the package before it is submitted to the Office of Administrative Law. It'll then go through agency and then the governor's office. We offer this as a courtesy review to boards as well, but it is not a requirement. Next, I'd like to briefly discuss the department's efforts related to standardizing data. We've talked a little bit about data here today, and I think this is something that will probably be of interest. Regarding performance measures, in 2010, in response to a realization that many healing arts boards were taking up to 3 years on average to complete an investigation and take action against a licensee, the Consumer Protection Enforcement Initiative was launched. A goal was set to first reduce these timelines to an average of between 12 and 18 months by focusing on the following issues: staffing, technology, training, and metrics or performance measures. The performance measures were developed in partnership with the boards and an enforcement expert. The goal was to measure as many standardized enforcement processes as possible. For example, all boards have processes for intake, investigation, discipline. However, many differ on exactly what activities fall into those areas. This is also the reason many boards differ on performance measure targets. Since 2010, the department has been gathering data on complaints, convictions, case aging, and enforcement times. The department uses this data to work with boards to increase efficiency in its processes. Beginning next year, the department expects to begin reporting more detailed data on timeline and processes. Capturing and reporting more accurate data within the core performance measures will give the department and the boards additional information to review and analyze to ensure consumers are being protected. Lastly, I'd like to outline how the boards and bureaus look at applicant convictions. For each board and bureau, applicant convictions are dealt with on a case-by-case basis. In general, a board or bureau may deny a license only if the crime or act is substantially related to the qualifications, functions, or duties of the business or profession for which the application is made. For example, if an applicant for a security guard license has a previous felony for breaking and entering, the Bureau of Security and Investigative Services will look at the specifics of the case to determine if a license should be issued. If the facts of the conviction are substantially related to the duties of the profession, then a license may be denied. Other convictions would be considered differently for other licensing entities, and in the case of boards, the ultimate decision regarding licensing is up to the board members. We continue to look at how boards and bureaus license individuals and seek to ensure that unnecessary barriers are not created. However, the department would caution looking at a one-size-fits-all approach to dealing with applicant convictions. Finally, I believe the department plays an essential role in protecting the state's consumers.
Before you move on, question about the substantial relationship test.
Yes.
First, just as a factual matter, is the issue of, I believe the phrase was used was substantial rehabilitation. Is that part of the nomenclature for licensing?
So, two different things. So substantial relation is looking at the act or the conviction to see if it's related to the profession. The rehabilitation is another pathway to mitigate the conviction when applying, or if you're already licensed and they're seeking to take action against it. So the question is, do you have a conviction? Is it substantially related? And if so, have you been rehabilitated?
Okay, so if I have a conviction for fraud, I suppose that speaks to my probity and moral character. Presumably that might be substantially related to any licensed occupation.
Perhaps depending on the circumstances, maybe depending on the age.
So if I'm convicted at the age of 20 for a felony that involves some moral turpitude or some element of dishonesty, fraud, I'm situated differently 20 years from now if I apply for a license as opposed to someone who has the same conviction at the same age and applies 5 years later?
I think that would speak to the elements of rehabilitation.
Yeah, I think you're saying, is there a substantial relationship? That's first test. If there is,
Right.
if you get to that test, then you go and say, okay, now if there was a substantial relationship, has there been substantial rehabilitation? Substantial rehabilitation, as I understand it from your testimony, is not a separate.
It's a mitigating.
It's a mitigating factor to the first issue.
Right.
I think that's, is that right?
That is correct.
Right. And so that's, I understand, but let's start with the first point, which is, and I gather you're just acting on the statutory requirement, which seems hopelessly vague and troubling to me from the point of view of an administrator who's being asked to make that decision, unless it's purely a matter of looking at a grid and saying that I'm trying to become a licensed real estate broker, and I had or a licensed bank examiner, or whatever the occupation is, and I had a conviction for fraud. It almost drives to the inevitable conclusion that a fraud-based charge bears a substantial relationship to either of those professions, and they're out unless they can mitigate. That seems very unfair, particularly for somebody who's done his time and wants to get on with her life and has passed all the requisite tests to enter into a profession where it's almost an irrebuttable presumption that, say, that fraud-based felony conviction would bear substantial relationship. You might as well tell that person, come back in 15 years when they have substantially rehabilitated themselves. So I sympathize with the licensing agency that has to make those decisions, but they seem fairly, as I understand, sort of mechanical. Am I wrong?
And let me just get clarification for the term of art. It's not substantial rehabilitation, it's just rehabilitation.
Correct,
Okay.
correct. Substantially related, and then rehabilitation.
So
Correct.
let's focus on that, which is...
On the rehabilitation
Yeah.
part?
No, substantially related.
Okay.
Is it almost a mechanical application where you look at the crime and you look at the licensing, the job that they're seeking a license for, and you say it's substantially related, and that's the end of it?
So first, I just want to say that, just by way of background, the department does not do any issuing of licenses. We don't take enforcement. So there are the 40 entities underneath us that do that in a semi-autonomous manner. So I just want to give you my perspective in answering the question. Is it mechanical? I don't believe so. And I believe because it is written in the way that it is to allow board members, when they're making the ultimate decision, to look at all of the facts in the case. And when a conviction comes in on, let's say, an applicant, the applicant writes their own assessment and tells their own story to the program. So they have an opportunity to discuss what happened. Was it the 5th DUI, or was it a DUI on your graduation day? It was a one-time thing, and there's been no problems after that. So I don't know that that it is mechanical. From my standpoint, I don't believe that it is.
Director Ryan.
Well, hang on, I just got to follow this up. Because how about this for a license? I get out of prison. I've done my time, and I was there for or county jail for 30 days for a second or third DUI. And after the period of time where my license is suspended, I want to get a new license to drive. I may be wrong about this, but my recollection is there's constitutional authority for the proposition that the deprivation of a driver's license after the completion of a criminal service would be a violation of property and liberty interests. It seems to be no less of a compelling argument for any other licensing setting. So, in other words, I don't understand why there is any substantial relationship once that individual's gone through the so-called process of rehabilitation, i.e., doing the criminal
Jail time.
Yeah.
And I think that this was mentioned earlier, that rehabilitation doesn't necessarily equal you've done your time. I think for the programs under the department, and I can only speak to them, that it's a matter of looking at the underlying action and the profession in which you're going into. Let's say that you're going to be a clinical social worker, and it is your third DUI, and I think what is looked at there is a pattern of underlying behavior and judgment issues. If you're making decisions that are not only injurious to yourself, and you're using a substance that, to the point that you could cause public harm, are you somebody that should be a licensed clinical social worker?
Good.
Thank you.
You'd indicated that the department is in the process, can you hear me?
I'm sorry?
Can you hear me?
Yes, I
Oh,
can.
yeah. You'd indicated your department was in the process of collecting data.
Mm-hmm.
Can you ask all 40 of those agencies that you oversee to provide next 6 months some indication of who they're turning down, and how many they are? Because apparently we haven't been able to find that data.
So it seems like a very straightforward question. I think that, yes, we can. Where it becomes complicated is IT systems. Not all of our programs are on the same IT system. They don't all collect the same type of data. Some may collect data that say, we denied this license for this type of conviction. Others may just denied for conviction. So it depends on the data actually being taken in and then what we can report of that. So certainly we can look into that and see what baseline we have across the board.
Could I just interrupt for a second?
Sure.
It doesn't seem like you're turning down that many people, and it doesn't seem like it's that difficult to just say to the director of that commission, will you just the next 6 months give us a report on how many you're turning down and why? I mean, you can almost write it down in pencil, you know.
Well, it really depends on, like, for Board of Registered Nursing, they have over 400,000 licensees. They're quite high volume if you look at some of our other licensing entities that have less than 1,000. You're right, it's a scratch point, right?
Well, no,
Somebody's
that'd be
writing
good.
it
If you've
down.
got 400,000 applicants or licensees, it would be good to know what percentage of those have tried to be, because we are in desperate need of nurses and phlebotomists and all the allied healthcare folks. So
Right.
just from our perspective, I think it'd be worth coming back in 6 months and just saying, what's really going on out there?
Yeah, a related question, and my fellow commissioners can correct me if I'm wrong, and I probably am. The first hearing, we heard from legislative staff of people who review the licensing schemes. And I recall, I think, asking questions about racial and ethnic gender diversity, and was told that those statistics were not available. And why is that, and do you have them, and why don't people collect that information? Because it seems as though there is not a legitimate privacy consideration for somebody who's applying for and obtaining a state license. In other words, you're voluntarily submitting something in exchange for what seems pretty clearly a government benefit. And we're not talking about identifying individuals by race. We're talking about a collection of data. So do you have any insight into this question of race and ethnic and gender diversity?
The information that we request on an application, we must have the authority to request. And so there are a number of acts for our professions, registered nursing being one of them that does collect that data because the explicit authority is in their statute to allow them to collect that data. I think there might be a couple others, I can't remember off the top of my head, that also collect data, but not all of them do because they don't have the authority to do it.
So this seems like a strange rule, because if the goal is to increase general well-being usually flows from increased economic activity and upward mobility. And if you have no insight into whether the licensed occupations are being discriminatory because you don't collect the information about racial and gender diversity, there's something fundamentally unfair about that, because you're not going to be able to identify whether the licensing scheme is an impediment because you have no idea of what the input is.
The simple solution is, if you don't have legislative authority to do it now, simply almost get a piece of legislation passed along. Taking notes right now.
Yeah, I have a question because it's never been clear to me. Maybe you can explain it. The relationship of the Department of Consumer Affairs to the 26 boards. And let me sort of tell you what it is I'm asking about. if I'm on one of the 26 boards, what do I have to do for you as the department, if anything? And what is the extent of your authority to compel me on the board to do anything?
Very limited. The department is an umbrella entity that, for the most part, we provide services to the programs under us. We have human resources, we provide legal services, IT services, but as far as oversight, for the most part, it's very limited. As I stated, with rulemaking, we do review the rulemakings. However, we can only deny based on public welfare. So the department's oversight role with the semi-autonomous boards is very limited.
And
So, Mr.
Go ahead,
Chairman,
yeah.
so I don't want to litigate the North Carolina dental case, but isn't one of the criteria that one would look at with respect to the independence of the board where their licensed occupations have a majority role? Isn't it the view of the department or the state that the supervision of those boards where there's a majority of licensed occupants, that you do a lot of oversight? So that what you just said seems to contradict that. So maybe you could help us reconcile.
No, that is one of the issues with the North Carolina findings, and it's something that the department is working with folks in the legislature and the governor's office on finding some legislative solutions to mitigate that.
Okay.
I would add that, what would you describe in terms of the progress of those negotiations? Pretty slow and methodical, correct? Because it's so broad what the implications might be.
We've been working on it for many, many months with the legislature and the governor's office, and I think that we are definitely in a good place, and I think that we are in agreement of what those solutions look like.
Oh, we are? Are they public? Are they public
Not
information?
yet.
Yeah, okay, all right.
So let me try to get an understanding. So we've heard over and over again issues pertaining to prior convictions and the substantial relationship, and then the consequences of an interpretation of rehabilitation. So I guess what I'm hearing is that of those 26 boards could theoretically, within a certain band of definition, define those things for themselves 26 different ways.
Of what would be cause for denial or revocation or suspension?
Right.
Yes. It's outlined in the statute or their regulations or both,
Right.
what unprofessional conduct is and what they can take action for. So it is outlined, but definitely their individual acts, different professions.
And so it seems to me that in order to address the issues that we heard from, for example, Michelle Natividad Rodriguez and C.T. Turney, in terms of what they experience with the people that they're trying to help, that there's 26 different targets. And the personalities of the people on the boards is in all likelihood going to define the culture of the board, which results in how they define substantial relationship and rehabilitation. Right?
Right. The only thing I would add to that is that there are overarching code sections in the middle or in the beginning of the Business and Professions Code that for the last couple years have been changed. I worked with Michelle a couple years ago on some legislation that can lay over the 26 different acts. The bill that passed a couple of years ago, 2396, talked about taking in consideration expunged convictions. And so you can lay that over, even though you do have all the different variables. There are certain things that you could lay overarching on those licensing acts that may make the pathway a little bit easier.
Okay. Thank you. Any further questions from Commissioner? Seeing none, I want to thank you very much for your testimony. Yeah, this is the time when members of the audience, should they wish to, can offer public comment. And staff has indicated that there aren't any requests at this juncture. So before we adjourn the meeting, I want to make sure that anybody who's in the room who wants to comment has a chance to do so. Going once, going twice. Okay. Thank you very much. And with that, thanks, everyone, and we'll adjourn the meeting.